Britain's judges are often referred to as incorruptible, but since we presented evidence of the absurdity of that notion, the mask has been slipping. We know the truth, and so do increasing numbers of you. We revealed 18 months ago how decisions are really being made in the corridors of so-called justice. And today, we're back with more. We are Hunt and Gather, and you are watching The Other Night.
A lot of people are talking about the creeping corruption of Britain's judiciary these days. We've been talking about it since December 2023 when we released episode 1 of The Other Night, which has now had more than 1 million impressions on X and been challenged by nobody. It details the behaviour of 2 senior judges, which goes against their own rules and we believe goes against the law too. Lord Justice Sir Stephen Mayle sits in the Court of Appeal. Mrs Justice Sarah Cockerell was, at the time of these events, a judge in the Commercial Court.
She has, since the publication of our film, been promoted twice. Once to the Court of Appeal and now to the post of Deputy Head of Civil Justice.
Yet still, she hasn't answered our concerns about her conduct. And what we have uncovered raises serious questions about the impartiality and the integrity of Britain's justice system.
If you have ever sat on a jury, or if you have ever sat in a dock and been convicted by a jury, you will already understand what judicial independence is. It's the reason juries are warned over and over again throughout a trial by the judge not to talk to anybody else about the case they're hearing. That's to safeguard their independence. They have to decide the case based on what they hear in court, and only on what they hear in court. If they go home and talk to their husbands, their wives, their children, their friends, if they go online and research the case, they destroy the independence of the entire jury on which they are serving. That's going to lead to a mistrial at best. At worst, it's going to lead to a miscarriage of justice and an innocent person could go to jail. Now, in a case where there is no jury, the judge hears the evidence alone. They make a decision alone, and that requirement to ensure independence falls on them alone. In fact, the judiciary is so keen on the idea of judicial independence, there is a whole section about it on their website. It is vitally important in a democracy, it says, that individual judges and the judiciary as a whole are impartial and independent of all external pressures and of each other. As well as, in fact, being independent in this way, it is of vital importance that judges are seen to be both independent and impartial. Justice must not only be done, it must be seen to be done.
And what we've uncovered is all to do with communications between these 2 judges and a third party that we say should not have been taking place. But before we look at those, we need to understand some detail about the case Mrs Justice Cockerell was hearing that led to these communications.
3 members of a family called King were suing their former business partners Prime Kings and Prime King's solicitor Teacher Stern over a costs bill they said was fraudulent. Their case was that the bill had been fabricated by forging a number of entries, inflating it to more than £2.2 million. Some of those entries were for expert witness work by Smith and Williamson, one of the UK's oldest, largest and most prestigious accounting firms. According to this bill, some of that work took place in 2016 and some in 2017. But the Kings were given a witness statement by Smith and Williamson that says they didn't start work on the case until 2017. Though one of their partners did meet with Teacher Stern's Rod Cowper in 2016, Smith and Williamson seem keen to point out there was no work done or time billed until the following year.
Now, with this witness statement, prepared you can be certain following expensive legal advice, Smith and Williamson were assisting in a legal action against their own former paying client. Now, that isn't something an accountancy firm would ever do, in our opinion, unless they felt they had no choice. And it seems possible that Smith and Williamson were uncomfortable with their name being on a forged document, and it seems possible that this witness statement was their attempt to make sure it was known that they hadn't been involved.
But Dame Cockerell's view of that evidence? Well, look at the transcript of a consequentials hearing a month later. The claim lacked rational basis at the very first stage, she says. The claim was totally without merit. I am going to certify this case as having been totally without merit. Whilst Smith and Williamson might be left to wonder why their evidence is considered of such low quality, consider Justice Cockerell's conclusions in the light of what she did after handing down this judgment.
Mrs. Justice Cockerell found in favour of the defendants, and in her judgment she was highly critical of the claimant's legal team. In response to that criticism, they sought disclosure via means of a subject access request, known as a SAR, of communications regarding the case.
One of these emails, which we obtained from the claimant, forms the basis for our investigation. It was sent by Mrs. Cockerell at 10:06 a.m. on the 26th of April 2021, 6 minutes after she handed down the judgment. It includes a copy of it and was sent to somebody with no professional involvement in this case, Duncan Matthews, a barrister. It's an email with the subject line "A heads up," and it's an email that the public and the parties to the case were never meant to see. Mrs. Justice Cockerell and Mr. Matthews are obviously friends. She's known him, she says, since about the first day of pupillage, i.e., since her early 20s. The judge already knew when she sent this email that the losing party was planning to appeal, because she had had this from their legal team the previous working day. It asks her to extend the deadline for filing their appeal. And you can see from her clerk's reply that the request was received and forwarded to her. So as she typed the email to Mr. Matthews, she knew that the case was ongoing.
So why did she feel the need to contact Mr. Matthews and send him her judgment when he had no professional connection to the case?
Now, when you lose a legal case, the right to appeal isn't automatic. You have to get permission to do so from a judge. And in this case, Lord Justice Males was selected to decide whether the Kings would get that permission. Clear separation is vital between the initial presiding judge, Mrs. Justice Cockerell, and the appeal court judge, Lord Justice Males. But we believe that in this case, that separation did not exist, because shortly before he refused permission to appeal on the 26th of July 2021, Lord Justice Males had some sort of meeting with Duncan Matthews and they talked about this case. Matthews, remember, had already been in contact with the case's presiding judge in April. We know about the Males-Matthews meeting because of the second email we have obtained, sent by the Lord Justice to Duncan Matthews on July the 28th. "It was a pleasure to see you the other night and to catch up on your and Chambers news," he said. "I did not want to say much then about the case of King versus Stiefel, as I was conscious that I had an application for permission to appeal to deal with and wanted to ensure that I approached it with an open mind. I have now refused permission to appeal." He also attaches a copy of his decision, and it's a draft copy, not the final version, that was sent to the parties.
So the trial judge, Mrs. Justice Cockerell, dismisses a case which has serious ramifications for the legal industry. It's all about inflated costs. She then has contact with a random third party. Duncan Matthews is a barrister, but he had nothing to do with this case. That random third party then goes and meets with the judge who is ruling on permission to appeal. That judge then refuses permission to appeal and emails Duncan Matthews to that effect, attaching a draft copy of his judgment. Now, when we asked the Judicial Press Office to explain this apparent triangle of contact between these two judges, and this third party, the story that we were given gave us serious cause for concern.
The Judicial Press Office is part of the Ministry of Justice. We asked them to explain this triangle of contact. It took them 2 months to get back to us, and when they did, they said this. Lord Justice Mayles and Duncan Matthews QC both attended a large dinner of the Commercial Bar Association. It is not unusual for judiciary and barristers to attend the same event. As here, judges are therefore careful not to discuss the merits of cases which are before them. Well, that sounded unlikely to us. This was still COVID time. Dinners and other gatherings of all sizes just weren't happening.
So we were now being given, as a reason for this meeting between Duncan Matthews and Lord Justice Mayles, that they met at a dinner. So we made some inquiries with some of the big hitters of the London Commercial Bar as to whether they believed that this dinner had actually taken place. Lots of them got back to us. Many of them said it couldn't possibly have happened. Just to give you a few examples, Sir Bill Blair, who's Tony Blair's brother, Tony Grabiner, one of the most high-profile barristers at the English bar, Lord Justice Lewison, and Charlie Falconer, who was the Justice Secretary under Tony Blair. All of them denied that this dinner could have taken place. So what is the truth?
And perhaps more significantly, what could possibly motivate the UK Ministry of Justice to tell such a big lie to a national broadcaster about something as important as the conduct of a legal case?
What is obvious is that those who sit in judgment on their fellow citizens must themselves be above reproach and not give rise to any situation that can raise questions about their integrity. Now, those questions in relation to these two judges undermine their role not only in the King case, but in any case that they have heard since.